Tēnā koutou katoa and hello everybody. Welcome to the Lento Intervention podcast. My name is Ben Adelberg and I'm coming to you from Tamaki Makaurau, Auckland.
And g'day, I'm Emma Strutt and I'm currently coming to you from Gungaloo country in Queensland. And before we dive into our conversation today, I'd just like to acknowledge the traditional custodians of country throughout Australia and their connections to land, sea and community.
The Lento Intervention is an Australasian educational and advocacy platform dedicated to raising awareness about the current climate and health crisis.
And on this podcast, we invite guests to chat about topics that will inspire you to take action to improve your own health and the health of the planet.
So please subscribe to and share this podcast and visit our website for the full show notes.
And don't forget to buy us a coffee if you'd like to support our work.
So on this episode, we talk climate risk governance. One of those topics that digresses a little from our usual conversations, but for some of our listeners, this could be a very important theme for your own business. So our next guest presented at the IDEA 2021 Planet Health and Hope Conference by the Doctors for the Environment Australia back in October, the same conference that we presented at. And in fact, she was the very next presenter after us.
Yep, so today we're sitting down for a chat with Charlotte Turner, otherwise known as Charlie, who is a Senior Associate in the Climate Risk Governance team at Minter Ellison, which is Australia's largest law firm. Charlotte is also the APAC co-lead at the Chancery Lane Project and specialises in climate risk through a finance, corporate governance and liability lens, with a particular focus on the health sector. So, Charlie, thank you so much for fitting us into your extremely busy schedule today.
Thank you very much for having me. It's great to be here.
Right, so you've literally got a plane to catch, so we're going to get stuck right into it. First, tell us a little bit about yourself, your background, and how you got involved in particular with climate risk governance.
Absolutely. So I started my legal life off in the UK as a disputes and litigation lawyer, and moved over to Australia about 7 years ago and joined Minter Ellison's dispute resolution team. And Minter Ellison is the first law firm to have a climate team that's dedicated purely from that corporate lens of climate risk governance, headed up by Sarah Barker, who's one of the international leading authorities in the area. And having always taken a keen interest in the environment and the planet, I would often come round to Sarah's office when she was in and knock on the door and say, please, can I do this? Can you teach me what you know? And just as the area of climate risk as a financial issue has rapidly grown over the past 5 years or so, Minter's actually formed a proper team in July 2019, and I moved across to work for Sarah then. So my practice has evolved from a disputes litigation into the more advisory risk governance, but still really with that litigation lens, and bringing that area of my work into my climate work.
So I think when people think climate change, a lot of people go straight to the environmental or the health risks associated with that. But obviously there's a huge financial component too. So just for the listeners, please dumb it right down for us. How is climate change actually a financial and liability issue, and what are some of the risks associated there that you deal with?
Yeah, absolutely. So in 2015, in his then capacity as the Governor of the Bank of England, Mark Carney really helpfully categorised the three main categories of climate risk as a financial issue. The ones that fall into the bucket of physical risks, and those are the things that we generally think about when we think about climate change. And in a health context, they really cover sort of risks but to the community, but also to service provision and the continuation and availability of service provision in the health sector after extreme weather events, and also the onset of those chronic weather events. The second bucket is economic transition risk, and those are the responses of the markets and the real economy to the physical risks of climate change, and these include regulatory and policy developments, technological advancements, and the whole range of stakeholder preferences, from the institutional investors right down to community. And the third bucket is those liability risks that stem from the mismanagement of those physical and economic transition risks, and the failure to disclose or manage them properly. And climate-related litigation has really continued to grow as an important driver of change, as it's really testing the boundaries of government and corporation obligations, and so being used as a real driver of change in the climate crisis.
Am I right in saying that part of the current challenge is that from a government level, it's not well set up, and a lot is falling back on the private sector or sort of more local level? Is that the case?
Absolutely, and it's a question that we get asked in our practice all of the time, especially by corporate and private clients, is, well, if the governments aren't setting the policies and framing what we should have to do, why do we have to do it, and where do the risks lie? And actually there is so much pressure, and the risks are being driven by those economy participants, institutional investors, the banks, debt and equity participants, that even without solid government action at a high level or at the federal level, there's so much risk and pressure coming from the real economy that without taking change, certainly in the private context, corporations are exposing themselves to liability risk. And as you said, there's real on the ground great change being driven at a state level, and also a local council, local government association level. And lots of the local governments in Australia now have declared climate emergencies and taking real steps to integrate climate risk mitigation and adaptation strategies throughout their council areas, and really working together with surrounding councils, recognizing that climate change doesn't recognize the boundaries of your local government authority. So having to form alliances and work together to deal with the cross-boundary issues that are occurring.
So there's certainly a lot of opportunities for a lot of the various sectors. Are there currently any obligations, or are those obligations coming from within the businesses themselves, say, or the private sectors, in terms of doing the right thing?
So in terms of legislative obligations, the way to deal with climate risk and think about climate risk is it's far from being a simple compliance function. It's a full risk management, an effective risk management strategy of climate-related risks. It really looks at it and comes from that due diligence perspective, and a diligent approach to managing risks. So while there may be a lack of legislation, the drivers are coming from regulatory pressures here in Australia. The corporate regulators are a real driver of change, as they have really got behind in recognition of climate risk being such a material financial issue. So ASIC has updated some of its regulatory guides to include specific reference to climate risk. APRA has recently released practice guidance, as has the Accounting Standards Board. So while there's not hard law in relation to the mitigation of climate risk, there's plenty of soft law coming from the regulators, and also those expectations from investors, and the increasing pressures for climate-related disclosures that come out of the Corporations Act. So the directors' duties and other duties that come out of the Corporations Act now, with climate change being a financial issue, it must be dealt with like any other risk to a business and managed and disclosed just like any other risk. So while there isn't necessarily climate legislation at a federal level, noting that in Victoria there is a Climate Change Act, but lots of the pressures and the requirements actually come out of existing corporate laws.
And I mean, you mentioned that drive for corporate change here. I think consumer demand for corporate sustainability is definitely on the rise, which is fantastic. But unfortunately, because of this, you could also argue that greenwashing is something else that could potentially be on the rise too. But greenwashing actually comes with some legal risks. So talk us through that and what kind of steps should companies actually be taking right now?
Absolutely. So greenwashing is really simply a misrepresentation of sustainability credentials of a company or its products and services. And again, it's not really a new source of legal and reputational risk. However, again, with that sharp evolution of sustainability and climate change in particular into a material financial risk issue, it has now become an acute source of legal risk for both for commercial corporations, financial institutions, and governments. And with heightened demands on corporate sustainability, as you say, from investors, from consumers, there is real elevated scrutiny now from regulators and strategic litigants to make sure that companies and business, if they're saying or making representations that a product or a service is green, that it really is. And the greenwashing risks really fall into three buckets of misleading and deceptive conduct. And increasingly, we're seeing claims in relation to greenwashing. The first bucket relates to greenhouse gas emission reductions targets. So with there being a real proliferation of setting net zero commitments and sustainability targets, commercial corporations and the like are really scrambling to meet the heightened expectations on net zero emissions by 2050 and really coming into line with the expectations and the Paris Agreement goals. And that term net zero implies significant interim reductions over the short and the medium term, and therefore real care has to be taken when setting these targets, as they might be misleading if those targets have no reasonable basis, there's no genuine intention to pursue them, or there's no credible effort towards implementation. And what we have really seen within the past 12 months is a super heightened focus on you've set a net zero target, but how are you implementing it? And if you've got no credible basis or genuine intention to do so, then that's just greenwashing. The second bucket where greenwashing claims are falling into is this truth to label. So being held to a tighter account on their terms, such as sustainable or green, to a more defined and much higher standard of conduct. And finally, the third bucket is the advertising of corporate credentials or products. Consumer protection regulators are increasingly scrutinizing greenwashing in advertising claims. And there is a large focus from, as I've mentioned, both the regulators and consumers alike as to claims that are being made and where they can't stack up. Litigation is being brought.
Because exactly those terms, sustainable, green, etc., they are misused. Their definitions are very loose. And we've had conversations along these lines with a lot of past guests where certain components are completely removed from calculations. And for example, when we talk about greenhouse gas emissions in the dairy industry, they're not including the actual costs or the effects it's having on the environment, or all these externalities. It just seems like it's just a massive can of worms. It just seems like, well, who's actually telling the truth, if anyone? And what are you basing it on? Because it's a massive piece, isn't it?
It is, and it's really difficult, as you say, because there's no real universal definition of what sustainability is or green. However, there are frameworks both that are sort of emerging and coming into place, such as the EU's green finance taxonomy, which is starting to raise the bar on when such terms can be justified. And with these emerging standards and the elevated market expectations around definitions, it's becoming more important than ever to be really clear about exactly what labels mean and how they're credible. And with this heightened focus on ESG and green labeled products, truth to label has emerged as a particular focus, certainly for financial institutions in last year, but also in the consumer forums. A case that's been filed in Australia, the Australian Centre for Corporate Responsibility filed a claim against Santos, and part of that claim was in relation to misrepresentations or alleged misrepresentations as to the nature and quality of the characteristics or of the goods and the services, and they were alleging that they may contravene prohibitions against specific misrepresentations under the ACL, the Australian Consumer Law. And that was in relation to the use of Santos saying in their annual report and referring to natural gas as clean energy, and suggestions that they were conveying a misleading impression that the extraction of natural gas and the generation of energy using natural gas was misleading to consumers by stating that it had it was green or cleaner. And similarly in the UK, an environmental NGO called Client Earth alleged that BP had misled the public in the way in which it presented its energy business in advancing advertising campaigns in violation of the OECD guidelines for multinational enterprise, because they were representing the business as low carbon in the campaign, but actually BP's capital expenditure in renewables was about 1% relative to its fossil fuel energy. And we've seen recently complaints brought against Oatly, for example, for misleading claims. And so while it's a real minefield with there being no clear definitions of what green or sustainable means, there is more and more challenge and scrutiny to the use of these words to make sure that consumers are not being misled when they're making decisions in relation to products.
I don't even know how or where you start with this. As a lawyer, how closely do you have to kind of link in with academics and scientists to actually know what the data is before then progressing with your case?
Absolutely. It's one of these areas where certainly from an advisory perspective, it is, because we're not just thinking about regulatory compliance and thinking, sort of all of the other pressures that the science and the economic take on things. We have to consider everything. But when it comes down to actually the disputes and the litigation, all of these cases are being brought under pre-existing commercial and corporate legislation. So while there is, for example, for the evidence base of it, you would have the scientists and the economists and bring those elements into the claim as the legal claims. And there are lots of really novel claims being issued by strategic litigants at the moment. They all still are within the bounds of pre-existing legislation. It's just framing these issues in the legislation that exists. But it's a really difficult area, and one that is evolving so quickly that has to bring in experts from all over the field.
And I do have to ask your opinion on something here, given the timing of our recording. Please, absolutely no pressure to answer this if you're not comfortable to do so. But hot news in Australia at the moment. I hope most of our listeners will be familiar with the 8 teenagers and the nun that previously won their case against the federal environment minister. If you're not aware, just to set up this question a little bit for our listeners, Their case was relating to the expansion of a northern New South Wales coal mine, and they argued that the minister had a common law duty of care to protect younger people against future harm from climate change. Big news a couple of days ago at time of recording is that the minister had successfully appealed against that decision. So basically, the appeals court is ruling that the minister does not have a duty of care to protect the youth from the climate crisis. So any comments on that case at all? Or, where would that group of teens go from here if they wanted to progress further?
I think that a really an important point from the determination of the full federal court the other day, that while the appeal decision has overturned the legal basis for a novel duty of care, it hasn't changed the facts. The primary judge found that climate change poses a very real and existential threat to the lives of Australian children. And in that landmark judgment, found that death and injury arising from climate harm will largely be inflicted by the inaction of this generation of adults, and made some really strong commentary within that judgment. And significantly, the full bench of the federal court rejected the minister's attempts to challenge the court's finding of fact. So while the legal basis for a novel duty of care, that decision has been overturned, the facts have not, and that in itself can be really influential in cases going forwards. And the critical finding by the court that emissions from a new coal mine pose very real risks to the lives of Australian children today. Those findings can accelerate and may well have the outcome of accelerating climate litigation building around the world. There hasn't been an indication yet as if the children and the nun will appeal to the High Court. But so while it was a loss legally, the findings of fact still stand, which is significant.
Now, most of us have signed an insurance form of some sort, whether it's travel insurance, contents insurance, car insurance, whatever. And we've always come across this term force majeure. Now, is that we've just had this conversation about defining certain terms. Does this term now need to be redefined when we're now starting to see more frequent occurrences of, do we call them force majeures? Major fires, major flooding, etc. There's a lot more of these greater extreme events occurring. Where do we draw the line with that? And how do we better protect ourselves in those situations?
Absolutely, and it's one of the areas of litigation in the climate change context that's been starting to be given quite a lot of attention and thought. Really, those testing the efficacy of these force majeure clauses, as you say, in the context of reasonable foreseeability of climate risks, and historically, force majeure clauses, have allocated the risk of events which were beyond the control of the contracting parties. So the idea that it's an act of God, which has prevented performance of the contract by the affected party. And under the boilerplate force majeure regime, affected parties would typically be excused from performance of their obligations during the period of the uncontrollable or unforeseen event, with each party bearing their own costs of overcoming that particular force majeure event. And over time, the scope of force majeure clauses have evolved from generally excusing the risk to the parties of such events, and they've really become quite highly negotiated and narrowing a sort of shopping list event now, which could constitute force majeure in the context of which contractual obligations are live. For example, it's quite common for parties to expressly allocate the risks now in specific weather-related events, for example, a cyclone or a flood, to a party even if the counterparty is unable to perform its obligation under the agreement because of that event, it is not entitled to relief by operation of that clause. And a contrary position expressing, including it in the scope of the clause, then protects a party who's unable to perform its obligation under the obligations while the event or while the act of God or the event is resolved. And they're really tricky clauses now, because in some circumstances, contracting parties who are starting to take a highly negotiated position could actually lead to a perverse outcome where, despite the parties turning their minds to the types of risk which constitute a force majeure in their contractual context, a risk outside of the control of the parties arises, but then it isn't expressly dealt with, and it leaves them vulnerable to claims outside of the contract. And as you say, it's a really difficult evolving area now, because how do you now define what is an unforeseeable risk or unforeseen, given the advances in the climate science and what we know now about the increase in frequency and ferocity of climate events. And the recent case study that we think about when considering and giving our clients advice on force majeure clauses is a case that came out in the US following the big freeze in Texas last year, and looking at the unprecedented weather events, and basically they're not analogous with historical force majeure events. And a continuous theme that we always give advice to our clients about and talk about is when we're thinking about climate change and the mitigation of climate change risk, we say, like, history is not a valid analog. The future is going to be very different, so we have to think about things very differently. And the case that I just mentioned was a case in the New York Supreme Court, and it arose in the context of a widespread power system failure in Texas after what was referred to as the polar vortex storm in February last year in 2021. It caused 70% of the state to be without power in freezing temperatures for quite an extended period of time, and contributed to a large, really tragic loss of life. And during the blizzard, energy generation was halted at Stevens Ranch, who was the claimant in the case, wind farm, because the wind farm's turbines had frozen over, and therefore they were unable to meet their supply obligations under two fixed power purchase agreements with Citigroup, who was the defendant in the case. And Citigroup sought compensation from Stevens Ranch for the costs associated with the outage. And I think it was around $113 million that was spent buying electricity from alternative suppliers, where the rates rose in that time from what usually was around $30 a kilowatt to over $9,000 per kilowatt during the blizzard. And so for the Citigroup to fulfill its own obligations to third parties, it had to pay those really exorbitant prices for the power and try to recover them from Stevens Ranch. And Stevens Ranch sought to rely on the force majeure clause to excuse their failure to supply due to the extreme unanticipated event. However, the court found in favor of Citigroup, finding that notwithstanding the storm was unprecedented in force and effect, such weather would not likely excuse non-performance under the contract. And the judge made specific references to reports that had concluded that such winter storms were likely to take place in Texas going forwards, and recommended that wind farm operators take preventative measures and to winterize, I think the term that was used, turbines. And specific reference was made in that case to the role of climate change on the impact of the frequency and ferocity of extreme weather events beyond those historical baselines. And so that case really nicely highlights and summarizes the risks of just reliance on force majeure. It was an act of God. It was unforeseeable. Therefore, I should be excused from my contractual obligations. And so while on the one hand, force majeure clauses are going to be negotiated. There's that risk that I just mentioned before about them becoming too highly negotiated. So it's a complex area to work through.
Yeah, it sounds super easy.
Yeah, and I think just drawing on the points that we talked about in your audience questions, really for like boards and executives and legal teams to really consider when they're thinking about these force majeure clauses. That case is a real salutary reminder of the criticality of bespoke approaches of force majeure drafting to efficiently identify, price, and allocate risks, certainly in long-term contracts. And that forward-looking approach to climate-related physical risk requires boards, management, and the legal teams alike to have an understanding of the risks and the opportunities of physical climate-related risk based on the best available science predictions, and be aware of the particular risk exposures in their unique context of each asset, each contractual arrangement in question. And it's just a real good reminder that certainly in a company context, management of climate risks should be integrated throughout the whole business. It isn't something for a sustainability team to deal with, or a siloed approach taken. It really has to take a top-down integrated approach to ensure that these risks are effectively managed.
Yeah, absolutely. So let's pivot a little bit now. You're quite involved in the Chancery Lane Project, which sounds like a really exciting, international collaboration that's helping move the dial in the right direction for law firms. So tell us about that project.
Yeah, absolutely. So as you mentioned at the beginning, I am the co-lead of Asia Pacific Chancery Lane Project. And Chancery Lane Project, which I'll refer to as TCLP, is a project working towards a world where every contract and law enables solutions to the climate change, and one in which every lawyer feels inspired and empowered to create and use solutions. So we are a collaborative pro bono collective of lawyers and legal professionals, but also environmentalists, policymakers, academics, sector experts from all over the world who have come together to rewire how we think about contracts and legal structures to enable solutions to climate change, and embed those climate risk mitigation tools that we were just thinking about. And in the work of TCLP, we support businesses and communities to embed net zero drafting solutions into their contracts, and really capacity build and skill up lawyers to help them realize that the skills that they already have and what they do in their day-to-day job, they have the skills to actually make transformational change and help fighting the climate crisis.
So you have a net zero toolkit available, which is, I even had a look through it, and as a non-legal person, I think there's a lot of really valuable guidance in there. Do you want to take us through some, or maybe the question is, are there some more important clauses within that people should always make sure that that's included, or are there maybe conversely more popular clauses that people tend to want to include? Every business is different, but are there, some more common ones?
Yeah, absolutely. I'll just start off briefly by talking about our Net Zero Toolkit, which we published in 2021, September 2021, ahead of COP26 last year. And the motivation behind publishing the toolkit is to help practitioners amend their contracts today to meet net zero goals, and in real recognition of the fact that this is still quite a new concept for lots of people. So as you said, there's lots of really great resources in there to bring people along the educational journey. And it doesn't matter if it's the first time you're thinking about net zero in the broader context or just in the context of your legal practice, but how those, it's really there to help lawyers and non-lawyers get up to speed with knowledge and how these concepts apply in your job, your organization, and your clients, why they're important, and how to embed them in your contracts. And one of the tools that we put together as part of the Net Zero Toolkit were some of these best in class contracts, contractual clauses, and they fit within our range of about, I think we have over 100 plus clauses now that have been drafted by the legal community, all of which go through a really rigorous peer review process to ensure a real high quality and high standard of work. And as you'll notice, each clause is named after a child. Every clause has a name, and that's in recognition that for the Chancery Lane Project, we are completely unattributable to any law firm and completely independent, but also in recognition that the next generation and generations to come is who this work is really important for. So our best-in-class clauses have taken 20 of the pre-existing clauses and amended them or retrofitted them so that they are Paris-aligned and meet those race to zero requirements to make sure that they're consistent with the Oxford Principles of Carbon Offsetting. What they do is they don't actually replace the earlier versions of the clauses. We have the earlier versions, which we refer to as light green versions. And these are still really useful because the clauses that aren't what we would call our best in class or really high ambition enable those contracting parties to use these clauses when they might not be as far ahead in their net zero journey or along the journey. So if you just put in really high ambition clauses into contracts or suggest really high ambition clauses where the parties aren't there yet, they'll just immediately get rejected and be seen as something that's too ambitious. So we have on the TCLP website, there is a clause timeline, and this gives a really good idea of the breadth of our clauses, has the majority of them in, and it's across the whole legal life cycle from incorporation, corporate governance, pre-contract, due diligence, procurement, disputes, and so that gives people a real overview of how many clauses and the breadth of them. And what we have found in probably the last year or so, or certainly what I found in my practice and certainly in the health practice, is the clauses that have become really popular are those clauses in the supply chain and procurement bucket, because as there's been this real increase in net zero targets and the setting of targets that cover not just operational emissions now, but scope 3 emissions, so those emissions that sit outside of the fence lines, a really effective way to implement net zero targets and exercise some control over your emissions, your scope 3 emissions that fall outside your fence lines, is through your contractual practices and your contracts with your suppliers. So our supply chain and procurement clauses are super popular. An example of one of which is Owen's clause, which is a clause that is a back-to-back or aligns a business's net zero target with its supply chain and its business partners, and that enables businesses to achieve its targets or take control of its own targets. And by setting emissions reductions to be achieved in relation to a contract and requiring emissions reporting and subcontractors to be similarly bound, both parties will be supported to achieve net zero. And if those obligations are not achieved, there is options for either termination or offset of the supplier's carbon emissions at the supplier's expense. And this promotes a net zero future, as the clause optimizes the ability of businesses and organizations to achieve their net zero targets. And that cascading of net zero obligations through a value chain accelerates the change in the economy and means these targets and these practices become much more commonplace.
And to not fall in the pit of greenwashing, it's one thing putting the clauses in, but it's another thing actually following through. So it's not just, hey, this is great, we've got these clauses, makes us look responsible, but there's a duty of care as well to ensure that it's actually actioned.
Absolutely. And that contractual obligation to do so does help, obviously, with that greenwashing element, and I think it's really important to stress here that the TCLP clauses need to make things better. We don't publish clauses that just shift risk and obligation and carbon around the market. They actually need to take those greenhouse gases out of circulation and make a positive difference.
It sounds like a really invaluable resource for anyone that this is actually applicable to. Can people get involved? How do they get involved?
Yeah, absolutely. So my colleague, both at Minter Ellison and the Chancery Lane Project, Phoebe Roberts, we run on Mondays, Australian time, Eastern Standard Time at 12:30 p.m. an onboarding session where you can come and it's just 30 minutes and learn about the project, the work that we do, some of the clauses, and then we offer one-to-one sessions for lawyers who may have a particular contract or a particular area that they're interested in learning about the clauses, and we'll run through them. And another really great way to kind of start off your TCLP learning journey is just to go onto the website, join up to the newsletter, become familiar with the clauses and the resources that are applicable to your practice area. And we have an event series that's running currently just in the UK time zone. So it's a little bit late in the evenings for Australian and New Zealand lawyers, but still manageable. But we're also looking at running some of those events also over in APAC. And one of the things I'd really like to plug for our TCLP APAC is running the facilitator training, so that we teach other people how to be TCLP facilitators, so they can either take them back into their business or into their law firm to really get, really promote as much impact as possible and get as much people talking about the project and using the clauses.
Now, in our very last episode with Professor Greta Petzel, one of the co-authors of the latest IPCC report, it's been made clear that what we've now seen with all these reports is that there's clarity and there's even more certainty of the occurrences of real climate-related events, big events that have a significant impact on our lives, on businesses, on our economies. So with that comes the challenges that comes in how we manage climate change related policies, how we administer it, but at the same time, the opportunities. So Charlie, we really want to thank you for this. This has been invaluable. We could continue on. I mean, it's probably the quietest Em and I have been in a while because there's just so much to take in. But like you say, for a business in particular, it's not to be siloed. Oh, it's the legal team. They'll deal with it, because everyone is part of it. Everyone needs to do their part. And this is why these kind of conversations, they're different for us, but they're important. So thank you so much for your time. The amazing work you do with the Chancery Lane Project. I think it's huge. It's amazing. So thank you so much for coming onto the show.
Thank you so much for having me. It's been great.
Thank you for listening to the Lentil Intervention Podcast. If you found this interesting, make sure you subscribe and share it with your friends.